Ready, counsel?
May it please the Court, Richard Plebana for the defendant, Mr. Morales. The factual issue for the jury in this case, Your Honor, was whether the Commonwealth had proven beyond a reasonable doubt that the defendant had not been engaged in self-defense. It easily could have done so, though it did not. There were various versions from both sides as to exactly what had happened. At least there was certainly evidence. Even the Commonwealth's witnesses agreed that the victim and his friends had initiated the confrontation between them. There was evidence that the defendant was backed up against a wall, surrounded by three people. All the while, Ms. Thomas was urging them to go get him. So it was a close question, or at least it was a question for the jury. Because it was a question, this particular instruction that the jury could consider the prior act of violence by the defendant as on the question of who was the first aggressor and on the question of whether there had been lawful use of self-defense, which is what the judge instructed, became crucial to the case.
Well, you wanted to present the victim's prior history of violence under adjutant, correct?
Correct, Your Honor.
So doesn't that open up the question of the defendant's prior history for violence as well?
I think that that is exactly the legal issue that's before the Court today, and I suggest it is not. If this was a sporting contest of some sense, we would need the same rules for both sides. But trials are not sporting contests. The purpose of a trial is to determine whether the Commonwealth, using proper evidence, has proven the charge beyond a reasonable doubt. There are a number of cases in which we do not treat the two sides equally. For instance, we have the humane practice regarding defendants' confessions. We don't have the equivalent for prosecution witnesses. We have the restrictions on the use of prior bad acts may apply differently to a defendant, where a prior bad act, even if, for instance, a prior conviction may be admissible under the statute, but may not come in because it is overly prejudicial. We don't have the same on the Commonwealth side.
Let me just get some clarification. Is the problem here that the evidence regarding the woman being hit on the head with a bottle by the defendant, that it came in at all, or is it the instruction that is the problem?
The problem is the instruction, Your Honor.
Not the admission of the evidence.
There was no objection to the admission of the evidence. The trial
You actually sought it, didn't you? Didn't you
Well,
want it as or didn't they want it as context?
To some extent, but not completely, Your Honor. I think what the defendant wanted was evidence that there had been confrontations, had been problems between this woman and her friends and the defendant. It's not clear that if he knew that this instruction was coming.
Fair enough. Now I understand that, but at the time that before that came up, the defendant, it wasn't just that he didn't object. There was some value to him of having that information before the jury.
There was certainly value to him in having evidence that there had been confrontations, that had been some sort of altercation between Ms. Thomas and Mr. Morales. Whether it helped him to know, whether it helped to have evidence that he had actually hit her with a bottle.
Right, but once you get into the, yeah. But let me ask, in terms of, we have this amended Rule 14 now, which provides, or will, well, I guess does now, provide for at least the Commonwealth giving notice of the evidence that it would put in if the defendant is going to put in evidence. And is it your position that you just think substantively that rule has gone the wrong way?
No, Your Honor, because I think the rule properly speaks to rebuttal evidence, which would be evidence that rebuts the existence of that prior incident that the defendant wants to put in. And I think that, I agree the rule is not completely clear, but I think that the fair way to read it is that The Commonwealth needs to know, and then needs to give notice that it's going to try to rebut the defendant's evidence that a certain incident occurred.
Why would the Commonwealth have to go through the machinations of giving rebuttal evidence if it was being offered for essentially the purpose that you're talking about? I mean, the Commonwealth, I don't want to say they have a right to rebuttal evidence, but for the most part, discretion is pretty broad in letting in rebuttal evidence for the purposes that you've just described. Why would we have a special rule for basically routine rebuttal evidence?
Well, I can't speak to the the reasoning of those who made the rule, or adopted the rule, Your Honor.
Well, it seems to me that the purpose of the rule was to let in the kind of evidence that, I mean, it's not really rebuttal. It's evidence to show that, no, you're the one that, or your client was the one that was the first aggressor.
Well, I don't read the rules going that far, but as to why, I think the court realizes that this is a sensitive area on both sides, defendant and Commonwealth, and that, to be fair to both sides, one needs as much disclosure as possible. Something like mental health evidence.
I get what you're suggesting is it's not clear that the rule meant to answer the question left open in adjutant.
Exactly, Your Honor.
That's the question we have to address.
Yes, Your Honor.
You're concerned about the judge's instruction, but let me back up on that just for a minute. When the evidence came in that you were trying to get in to show that the victim was the first aggressor, it came in for all purposes, didn't it? And if it came in for all purposes, couldn't the prosecutor fairly argue that it was your client that was the first aggressor, based on that evidence that was in for all purposes?
There was no limiting instruction, Your Honor. But I think it became, once the trial judge had ruled that he was going to give this reverse adjutant instruction, as it were, there was no sense in asking. He had indicated at that point he wasn't limiting the use of the evidence for this purpose. So it would have been futile to ask for a instruction on top of that to limit the evidence in a way that he had just ruled he wasn't going to limit it.
But are you saying that the prosecutor could not have fairly made the argument that, based on the evidence that was in for all purposes, it was your client that was the first aggressor?
He could not. Yes, I believe he could not have argued it for that purpose, that the evidence could be used for that purpose.
Why?
Because, Your Honor, we have the traditional rule that defendants cannot be. One cannot convict a defendant based upon his prior criminality or prior acts. And in this case, what the judge was telling the jury is that they could consider this prior bad act for the purpose of determining whether the defendant was guilty in this case.
But even if the judge didn't give that instruction, could the prosecutor have made the argument?
No more than a prosecutor can make the argument in any case that, well, we know that Mr. Defendant committed armed robbery 2 years ago, since he took the stand, and you should now assume he committed armed robbery today. That is an improper argument, and whether or not a limiting instruction.
But adjutant opens the door to this very issue by saying that you can admit evidence of the victim's prior bad acts to show essentially a propensity and a likelihood that they were the first aggressor. That's a new rule. That opens up an avenue.
Adjutant certainly, yes.
That's the whole point of these prior bad acts of the victim, to show a propensity and the likelihood, therefore, that the victim was the first aggressor.
Yes, Your Honor, and the question is simply that, is it proper, is it fair to reverse that and allow the same evidence to be used against the defendant? I suggest that, given its prejudicial nature, given the position of a defendant in a criminal case, it is not.
But why should a defendant who has the opportunity to not have this evidence come in by not raising the victim's prior violent acts also then receive the benefit of a one-sided approach to the issue of who was the first aggressor? I mean, the defendant here could have said, Your Honor, I don't wish to. I know I've provided prior notice of my desire to use adjutant. I don't wish to offer that evidence, and I wish a limiting instruction with regard to the hitting the bottle over the head, to say that you may consider that only with regard to the defendant's state of mind as to the possible motive of those who were confronting him. You could have done that.
Yes, the defense counsel could have done that, Your Honor.
But instead, he decided to offer the prior violent acts of the defendant, and doesn't that then open the door to the issue of whether or not both sides have engaged in prior violence in evaluating who was the first aggressor?
Well, relying upon adjutant, he certainly didn't know it was going to open the door, Your Honor, though he might have known.
Right, well, that's a separate issue as to notice.
Yes, Your Honor. But the question, yes, exactly, that's the question. Should it open the door? And I suggest again that, given the psychology of juries, given the position of the defendant, that it is extremely prejudicial to the defendant to let this sort of evidence in.
Now,
Even if he has put in evidence on the other side.
going to the issue of notice, is it your position that if the Commonwealth had given notice of its intent to offer the so-called reverse adjutant, that you would not have sought to offer the adjutant evidence that you brought in?
Well, I can't know what trial counsel would have done, Your Honor. Certainly there would have been a much larger question in his mind about whether to bring in, not to object to the evidence of the bottle.
Okay, but of course, in opening statement, defense attorney mentioned the bottle. So, I mean, this was well before
I may be wrong, Your Honor. I don't think he mentioned the bottle specifically, though he did speak of a conflict, of an altercation.
Or problems or something.
Of problems between them. I don't believe he mentioned the bottle.
But presumably you would have had this conversation even before the opening statements, if
Oh, yes, if
notice would have been given before even then. So this issue would have come to the fore before the actual trial started, I think.
I would guess, Your Honor, there would have been a motion to eliminate to resolve these questions before he decided what to put on as evidence.
And what to say in his opening.
And what to say, of course, what to say in his opening. Finally, I'll just say, finally, Your Honor, if the court does decide to to adopt a new rule in applying adjutant to the Commonwealth, as it were, I would suggest it's not fair to do so for this particular defendant who had no notice of the change and who made trial decisions based upon what was the law at the time.
But let's assume you're right as to that. Let's assume that they should have given notice. Where's your prejudice here?
Well, I think the prejudice is that, as Justice Botsford, I think, just pointed out, that the trial counsel could have made an informed decision about whether to put in his adjutant evidence, could have moved in limine to keep out certain of the Commonwealth's evidence, such as the bottle, if he had known that this was coming from the Commonwealth and that it was the law that it might be admissible.
But the counter to that, I would think, is that it was pretty central to the self-defense argument to say that when the defendant saw those persons coming at him with Miss Thomas by them, he was mindful that Miss Thomas and he had had this fight, and he had hit her over the head with the bottle, and that's why he thought that they were going to indeed attack him.
I think that it was important for him to probably, well, the incident itself, the jury would have heard that Ms. Thomas was shouting, "Go get him." And that was the Commonwealth's case. There was no dispute about that. Whether it would have been sufficiently helpful to put in the prior evidence of a fight, I don't know. But even if there had been, even if the defense had wanted to put in evidence of a fight, if I had been trial counsel, I probably would have moved in limine to keep out the attack on what was asserted to be an attack on Ms. Thomas, the defense that he was defending himself with the bottle. If there are no further questions, I'll rest the room.
Thank you.
Thank you.
Good morning. May it please the Court. I'm Catherine Semmel, appearing on behalf of the Commonwealth. It's the Commonwealth's position in this case that Judge White had properly applied the adjutant rule to find that once the defendant had introduced evidence of the victim's prior violent acts, the Commonwealth was entitled to do the same. This is not a new rule. In adjutant, the Court instituted a new rule, as it found in 2005, But in this case, the judge's ruling was based on a well-settled principle that evidence that might not otherwise come in can be permissible when the defendant opens the door by broaching the subject. It was clearly foreshadowed by the court's ruling in Adjutant, even though the court clearly did not decide the issue there, although Justice Cowan expressed some strong opinions on this score in dissent.
But if let's assume we grant you that, wouldn't the Commonwealth have to give advance notice to the defendant that if you offer evidence of the victim's prior acts of violence, we intend to offer evidence of your prior acts of violence?
That's certainly true, Your Honor, and that was discussed in Adjutant, it's discussed in the rule. This is an unusual case. In some cases, I think that it would be critical that the Commonwealth didn't provide notice. The way the evidence came in this case made it a strange case. The prior act that the Commonwealth relied on was already in evidence, and as the court has commented, and as the Commonwealth argued in its brief, was actually central to the defense theory of self-defense, why he was afraid of these people and why they picked a fight with him behind the liquor store that night. It was mentioned, certainly an opening statement, not in a negative way, but to tell jurors this is important, pay attention to this, because.
So why didn't the Commonwealth notify the defendant? It's in the rule, and he notified you.
Well, it's in Adjutant certainly at that time. The rule, of course, is new. I think, honestly, Your Honor, that the prosecutor was not intending to make an Adjutant argument based on that evidence. The issue was actually broached by the judge during the charge conference, that this evidence was in there and that it was his understanding and belief that the rule of Adjutant should apply and that jurors could consider evidence that was also in regarding the defendant. Prosecutor agreed. But the reason notice wasn't given was because I don't think that the prosecutor anticipated using the evidence in that fashion. But it was certainly in, it was certainly known from the first trial, if from nothing else, and it was certainly important to the defense.
Am I wrong in remembering that the judge basically allowed the defendant to put in the Adjutant evidence in part because the Commonwealth had already put in the evidence that you're just talking about?
That's exactly true. The judge applied the same principle of evening the playing field when he allowed the Adjutant evidence to begin with. The judge thought it was a very close call whether the prior act of the victim actually qualified under Adjutant and should have been allowed. And as the court will see when it looks at the sidebar discussion, that the court did feel that even though it was a close call and even though he wasn't sure it should come in, that an appellate court looking at the fact that this bottle incident was in there against the defendant would weigh that against any ruling excluding the Adjutant evidence in this case.
So how do we analyze this? Do we say that the judge erred in allowing you to offer the counter adjutant in the absence of prior notice and deal with whether there was prejudice, or is it your claim that because of these strange circumstances the judge did not err in allowing that evidence without advance notice?
I think that the judge did not err, and certainly in the rule that the court has promulgated, it says that notice may provide a basis for exclusion, and under these facts, it simply didn't for a couple of reasons. One is because the defendant was certainly on notice as to the incident, as to the facts of the incident, as to what the Commonwealth would argue about the incident. It was fully discussed at the prior trial in this case. In fact, the Commonwealth brought a charge that the defendant was acquitted of relative to the bottle incident at the prior trial in the case. So the defendant was well aware that this issue was out there and that it would be broached at this trial. As to notice that it would be used in the adjutant fashion, there's simply no reason to believe that the defendant would have acted any differently had he known that. He didn't.
Go ahead.
He didn't argue at the time it was discussed. He was surprised that, gee, I would have done it differently. He didn't file a motion for new trial to develop that fact. All he argued properly was that there was no law yet specifically saying the judge could do what he could do. And so I don't think it's
an objection to the prosecutor's argument itself?
there was an objection only to the instruction, I believe. So in this case, the purpose that notice would fulfill was fulfilled, both practically and with regard to the defendant's reasoning. He would have no reason to forego his own bad act regarding the victim to prevent an argument regarding evidence that was already in, I think is the bottom line.
I'm trying to think how we deal with this, because here, of course, the defense attorney did not, when that evidence came in, did not ask for a limiting instruction, as Judge Spina noted.
That's correct.
But could have.
Certainly.
So, and certainly in the absence of adjutant, if the defendant could have, we don't know whether or not the defendant could have said, well, I'm not going to offer my adjutant if that bottle incident now is going to come in for a different purpose than I wanted it to, which was to show self-defense. I don't want it to come in for this second purpose, and I won't press the issue of the prior acts of violence by the victim because I don't want the bottle incident now being used against me with regard to self-defense. I mean, how do we evaluate that where we have no clue what defense counsel is thinking?
I think that in instances where a defendant doesn't bring a new motion for new trial to develop any facts, the court has to assume that there was a reasonable strategy involved. Perhaps he didn't want to highlight the past evidence. Perhaps he didn't want to confuse the jurors because he so clearly wanted them to consider the past bottle incident for his purposes. I mean, it's impossible to determine, but it's the defendant's burden to establish impropriety, and the defendant hasn't even raised an ineffective assistance claim in this instance. So I don't think that the court can draw any conclusions that it was improper or unreasonable.
Is it also the case factually that there was no evidence of Carey striking the defendant, correct? No physical contact?
I believe so. There was lots of evidence about swings, possibly in fighting, but I think even the defendant said he wasn't sure whether he ever made contact.
Okay, and was the evidence in terms of the other people, was it undisputed or was it disputed?
It was varied. I mean, I think it was generally accepted that this was basically a one-on-one confrontation, but where the other people were around was unclear and disputed as to how close they were and so forth, and where they were positioned and so forth. I would note, I think that Your Honor is heading toward the issue of, first aggressor.
That's what we're talking about, right?
Yes. But specifically in this case, I would just note, because I didn't note in my brief, that this wasn't a case where there was actually an original aggressor instruction given. It wasn't I don't think it was
I mean, it's part of the self-defense?
Yes. It wasn't really the focal point of the argument. There was a lot of argument about self-defense, but it really went down to how threatening the situation was in general, whether the defendant had reason to be in fear when he was the only one armed and there were multiple people but unarmed. It was unclear how close they were. It was unclear whether he could have fled. All of these issues were discussed and fleshed out, but I don't think first aggressor really ever was a center point of this case, factually. If the court has no further questions, I would be happy to rest on my brief.
Thank you, counsel.
Thank you.